Ms. Yance?
May it please the court. I'm Catherine Yanez with Kynes, Markman and Fellman, and I'm here this morning on behalf of Jason Gilliam.
You want to reserve some time for rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes for rebuttal, if I may. Your Honors, it is respectfully requested that the court grant Mr. Gilliam a new trial because the prosecutor's improper closing arguments deprived Mr. Gilliam of a fair trial. This was a close case in which essentially the only disputed issue was whether Mr. Gilliam was telling the truth when he said that the alleged touching of the child AM was unintentional.
Interrupt you for the benefit of the barristers, for them to kind of get an idea of what this case is all about. In a nutshell, your client is appealing the conviction below based on, after a jury found him guilty as charged of 1 count of lewd and lascivious molestation on the victim between the ages of 12 and 15. And based on that, he was sentenced to prison, followed by years of sex offender probation. And you're before us because you're taking two issues on what you allege to be errors committed in the trial court. Is that correct?
That is exactly
Try to
correct.
summarize it for the benefit of the barristers so they have an idea what the case is all about, okay?
Absolutely, Your Honor.
But you have one comment that was not objected to, and the first comment is a comment about Adam and Eve.
That is correct. Your Honor.
Please persuade me that that rises to the level of reversible error.
Yes, Your Honor. I will proceed directly to that comment. So in the state's initial closing argument, the prosecutor made explicit religious references, repeating 3 times that this case is analogous to the fall of man, which, as the court noted, the prosecutor described as the biblical story of Adam and Eve. And of course, the biblical...
Well, he didn't go into chapter and verse. He just referenced it was the fall of man, and it was a choice, and it was the choice of your client to do to engage in the alleged conduct.
That is correct, Your Honor, and in doing so, he explicitly referenced, quote, the biblical story of Adam and Eve.
But that's not per se reversible error, is it?
No, Your Honor, that is not per se reversible error.
So can you explain how this actually prejudiced your client?
Certainly, Your Honor. So to start with, both federal and state courts, including courts in Florida, have condemned prosecutors' use of religious imagery and references in criminal trials. And I believe this case shows exactly why the courts recognize that the use of biblical allusions creates a high risk of prejudice.
And if I may, I'm thinking of Cannon versus State. I mean, Cannon versus State, I love what the court said, and I pulled it up here. You reap what you sow. And here's what the Supreme Court of Florida said, and I quote, no danger that any religion-oriented comments diminish the jury's sense of responsibility for its verdict or cause the jury to base its decision on religious authority other than on the trial court's instructions. And certainly back here, they use the term reaping what you sow. Would you agree with me that? And I pulled up the closing argument. This was in response to the defense. The defense meant, and this is my quote, the prosecutor said, the defendant's action and his choices that brought us here today, defense told you, end of opening statement, that this was a dozing man and a fall of the hand, because that was the whole theory, that his client fell asleep and his hand just slipped and managed to do an accidental touching. And so in response to that, to the dozing man and a fall of the hand, that's when the prosecutor said, well, what popped into my head was the fall of man, not fall of the hand, but fall of man, and it reminded me of the biblical story of Adam and Eve. So hearing all that, in my mind, the case below centered on the issue of accidental versus intentional touching. And so reference to the well-known story of Adam Adam and Eve, it's almost like Adam and Eve suffered the consequences of their intentional choice as a, which basically it corresponds to the disputed issue here. So wouldn't this be, it's what you reap, what you sow?
Well, to distinguish reap what you sow in Cannon versus State, I would point out that unlike Cannon versus State, where it was a very oblique, ambiguous, indirect biblical reference, here we're literally talking about the prosecutor telling the jury, this is like the biblical story of Adam and Eve, the story of original sin, the story in which
He wasn't reading from the book of Genesis. It was just it was not an extensive comment.
It was really just sort of a play on words. And maybe it was a little too cutesy by half, but that's really, he wasn't exhorting the jury to apply biblical law. He wasn't, vengeance is mine, and, it was just a follow the man instead of a follow the hand.
Be that as it may, Your Honor, referring to the Bible and specifically a Bible story involving the original sin that resulted in the expulsion of Adam and Eve from the Garden of Eden based on their decision to sin, that is by people of faith recognized to be the original sin that introduced sin to the world. There was certainly, that is a very, it's a big step in terms of an analogy.
So it's inherently prejudicial, but because of the nature of the story. Is that basically your argument?
In the context of this case, this was an extremely, extremely close case. Religious references are not necessarily reversible error, and the courts have recognized it.
So could one make the argument that the story has become so secularized as part of our history and tradition in the Western world that it is maybe in a sense lost its religious gloss?
I mean, one could certainly make any argument, Your Honor. However, here, this was not a literary allusion. This was not a reference to Shakespeare. This was what the prosecutor told the jury was a biblical story about the fall of man. It was an explicit reference to religion.
And then what the court told the jury was, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. And don't we presume that the jury followed the court's instructions?
We certainly do, Your Honor. However, again, this was an extremely close case. The jury could certainly have reached the opposite verdict here. And there is a real possibility that the jury's verdict was influenced by the prosecutor's improper arguments, particularly in light of the other improper arguments that the jury heard misstating the evidence. And unless the court has any further questions regarding the biblical references, I'll proceed to discuss the misstatement of the evidence, which I think is really a more grievous error here. So along with the improper biblical references in the initial closing argument, in the rebuttal closing argument, the prosecutor misstated the evidence regarding Mr. Gilliam's own words the night of the incident. On the controlled call the night of the incident, when the child asked why Mr. Gilliam touched her private parts, Mr. Gilliam said, "I don't know. It was an accident, really. I was not trying to do anything wrong. I'm sorry." Despite these clear words on the controlled call, it was an accident. I was not trying to do anything wrong. The prosecutor argued in his rebuttal closing that the jury could infer Mr. Gilliam's intent from the fact that he had apologized on the controlled call.
And I agree with that, and I know you've raised that in your brief, that the prosecutor kept mischaracterizing the testimony. But wouldn't you agree with me that the jury heard the entire call? control call. So they heard the defendant's statement that it was an accident.
Certainly, Your Honor, of course they did.
And also, during cross-examination, he also was able to examine, and he also, I think, during, when he chose to testify, he was examined, basically, again, mentioned that it was an accident. So, yes, the prosecutor said that, but at the end of the trial, going back to what Judge Yoakum said, that usually the instructions given by the trial court, whatever the lawyer says is not evidence, rely on your own recollection of the testimony. And so, given all that, why does this rise to the level of reversible error, in your opinion?
Certainly, Your Honor, and it is always, of course, the case that when a prosecutor misstates the evidence in closing argument, that the jury will have heard that evidence. However, where that improper closing argument or that misstatement of the evidence in closing has the potential to mislead the jury and deprive the defendant of a fair trial, courts nonetheless reverse, because notwithstanding that the jury is instructed that the arguments are not evidence, the jury hears that argument. The reason closing arguments are given is that they are persuasive and they are an opportunity for the for counsel to address the jury and summarize for them the evidence that they have heard. And here, it's particularly notable that it was the rebuttal closing argument. It was the last thing the jury heard before they went back to deliberate. And despite...
What do we do about the fact that it was not objected to?
So, Your Honor, two points on that. Certainly the fact that there was at least an objection gives the court the opportunity to take together and by which I mean there was an objected to improper closing argument, as well as an improper closing argument that defense counsel did not object to, gives the opportunity to the court to view all of these comments together and determine whether they denied Mr. Gilliam of a fair proceeding. And I would, in that regard, point the court to Caraballo versus State, where there were some improper arguments that were unobjected to, and the only objections that were made were general objections. The court held in Caraballo that reversal was required because the cumulative effect of the state's improper arguments deprived the defendant of a fair trial. Further, if the court concludes that Mr. Gilliam's conviction must be affirmed, excuse me, I apologize, I'm jumping ahead. If the court agrees with the state that this must be reviewed on a fundamental error standard, I believe this case meets the fundamental error standard.
And if, because I'm going back, and this is what you're alleging is the problem, I think, that I told. The prosecutor, this is on the stand, the following exchange was done on the stand. And you never ever want, this is the prosecutor asking the defendant, and you never ever once use the word mistake, correct? And the answer is, as far as the question, you never say, in fact, in that call, you never said the word mistake, did you not? And the defendant said, I said accident. So fast forward, the words accident and mistake was being interchanged. Why would this be, as the case in Jackson says, that the remark was made, perhaps it was inaccurate, that the stray comment, what the court said, would not confuse the jury, given the state of the evidence?
In this case, Your Honor, I think it was more than a stray comment. The defendant said on the call, and the call was played for the jury, the call was part of the evidence, and the defendant said on the call, it was an accident. I was not trying to do anything wrong. The prosecutor took that and in his rebuttal closing argued that Mr. Gilliam had not said, I didn't mean to, had not said that it was an accident, had not said, I didn't know what I was doing. The prosecutor repeated, Mr. Gilliam said, I'm sorry. And then the prosecutor stated that on the call, never once do you hear the word mistake, never once accident, never once asleep. That never comes up. And this case was about
But Lieutenant, don't you think that could have killed his credibility? The jury would say, wait a minute, when they confront him. I can't rely on what the prosecutor said, because we heard the control call, and the control call very clearly said it was an accident. Don't you think it could be interpreted the other way? That would be an undermining the prosecutor's credibility, that it didn't have any effect on them?
Certainly, that is one way the jury could have interpreted it. We can't speculate. We don't know what the jury did.
Yes, excuse me for interrupting. We want you to answer the question, but you're into your rebuttal time.
Oh, thank you. I will wrap this up quickly with the point that this was a very close case. There was only one issue in dispute in this case, and that was Mr. Gilliam's intent. And this misstatement of the evidence went directly to that issue, and that was how the prosecutor argued it. The prosecutor argued that the jury could make inferences regarding Mr. Gilliam's intent based on what the prosecutor said. Mr. Gilliam said the night that this incident allegedly took place, and what the prosecutor said was not true. That deprived Mr. Gilliam of a fair trial, and for that reason, Mr. Gilliam's conviction should be reversed, and Mr. Gilliam should be granted a new trial.
Thank you. We'll give you 4 minutes on rebuttal. Okay?
Thank you, Your Honor.
May it please the court, Cerise Taylor on behalf of the state of Florida. Your Honor, the two instances of comment that appellant relies on, neither of these, either individually or collectively, provide a basis for appellate relief.
I guess there's a story. There are two things you don't talk about in public, religion and politics.
That is true. And it's because it is a minefield. But in this case, it did not rise to the level of error that is reversible on appeal. And specifically, I think what's important when we look at the religious reference, it is couched in terms of choice, which this court has already made reference to. That is the basis for this comment, to say that we're talking about something that was an intentional act. It was a choice. It was not accidental. And the crux of the case for the defense is that this was accidental, that appellant fell asleep and his hand accidentally brushed his granddaughter's, the area between her leg and her vagina. And so that is the basis for their defense. And in response to that, the state is saying this was an intentional act, and that its evidence taken collectively establishes the intentionality of this act, which of course the court knows this is a jury question. What is in his mind?
But he could have made that point without having to refer to the Genesis.
I cannot disagree with that. And I think what Judge Rossi Newcomb was saying, that, you know, it is too cutesy by half. I have to agree with that. I don't know that it's ever a good idea, because it can lead viewers astray thereafter when we're looking at this on appeal, to think that it creates per se reversible error. But this court is aware that it does not.
And we probably don't know what the religious affiliation, if any, of any of the jurors.
That's right. And I do also think
So it's risky.
Yeah, sure. Definitely risky. And I think that the way in which this comes up, and when we look at other cases where people bring up things that are even more significant, like, you know, God's judgment and religious judgment, and exhorting them to rely on religious law versus Florida law, that's not what we have here. What we have here is an idea in a short trial that he hears the opening statement where appellant says a dozy man, the fall of the hand, and that sparks in the prosecutor. So then when, you know, a couple of hours later, when we're at closing argument, this is what comes up. But the point that the prosecutor was making, I think, goes beyond just this religious reference to envelop the idea of choice. And that's why when the appellant objects and the objection is overruled, the prosecutor comes back up and starts to talk again, and he says twice, we're talking about choice. This is what we're talking about here. And then he goes ahead to connect up the substantial competent evidence that supports that this was a choice. And I know from appellant's perspective, this was a close case. And if we were just talking about one statement by a victim and a denial by the appellant, we might be in a different position. But that's not what we have here, because in addition to the statement from the child, the testimony from the child, the totality of the evidence, appellant's conduct immediately after, the child's conduct immediately after the touching, appellant's conduct immediately after the touching, and appellant's statements after the touching, all of this evidence is, it creates this picture of the intentional act.
But the statements were entirely mischaracterized by the prosecutor in the rebuttal closing argument.
I would say that there is an incorrect statement. That I will not deny. But I think it is important that we're looking at the totality. As the court is aware, we're looking at the totality of this oral argument, or closing argument. And what the prosecutor says is, at the very beginning, the very first thing he says, when the child calls him, and we have this controlled call, which law enforcement established, a controlled call after the reported abuse. Later on that same evening, the phone call happens, recorded phone call with police. And when the prosecutor is characterizing that, the prosecutor says in rebuttal, the very first thing he says is not that it was an accident, not that it was a mistake, not that he was asleep. The very first thing he says is, I'm sorry. So that's true. And that reference to accident is accurate. Then he goes on and says, and never once do you hear mistake, never once do you hear asleep. That's true. That's accurate based on the transcript. What the prosecutor said that was incorrect is, and never once do you hear accident. And so that statement in isolation is false. The question is it harmful? And that is what the issue is before this court. Can that singular, isolated, false statement mistakenly said, I would urge. And the reason I say that is because there is no way the prosecutor thought he was going to mislead this jury into thinking this defendant never said accident when all the prosecutor did was bring this evidence to the jury.
So it's interesting, the question that I've asked of counsel, that sometimes that can backfire because the jury's being attentive.
I would agree.
And the jury would, if an attorney would say something that the jury said, that's not what I heard, that's not, that may undermine his credibility, that's out there. Again, we can't speculate, we cannot do that, but one of the things that the judge instructs the jury, what the lawyer says not evidence, rely on your own recollection of the testimony and evidence presented. And for the jury, if they follow the instruction, then the question becomes, did that statement, coupled with the biblical statement, does that rise to the level of reversible error for him to get a new trial altogether?
Right. I think that is the question in this case. And just going back to this receipt of the evidence of the accident. Again, this was a short trial. The prosecutor began the opening statement by playing the controlled call. So from the outset, it is established what this individual said during the controlled call. Then during the case in chief, they play it again. Then cross-examination, during when the defendant takes the stand in his own defense and he testifies on cross-examination, again, the prosecution elicits this evidence of, hey, this was an accident. That's their position. It was a mistake. It was an accident. It was unintentional. And so all of this evidence, plus that the court twice instructed the jury what the lawyers say is not evidence, to give this jury a framework as they're considering the evidence. And so we have all of this. And so in order for this court to find reversible error, it would have to be that we have a jury that completely disregards the evidence that they just shortly moments ago heard, and that they disregard the court's instruction.
Is it a standard instruction under Florida law for the jury, the jurors are to rely on their own memories?
Yes.
Because I only saw that given here in the context of don't rely on other jurors' notes, but not in conjunction with what the lawyers say is not evidence. And if you hear something different from them, rely on your own memories.
My recollection of that specific area of the record, I would defer to you because I don't have the evidence before me and I don't have my direct recollection. What I do know is that there was reference to note taking because I apologize. Defense counsel said during the course of their closing argument, you guys have been paying really good attention. I know you're taking notes. So there was a reference to that, as well as a reference to the recording of the control call in which the word accident arose. both the defense and the prosecution say during their closing arguments, and you're going to have this recording and you're free to listen to it. Go ahead and listen to it. It's available to you. It's going to be in the jury room. So this is information that even if the jury was like, did the guy say accident? They have the information in front of them and they can look it up and they can verify, at which point they can then look at the prosecutor and say, this guy said it wasn't here. I've got the tape. It clearly says it. And so that could impact the reliability of the state's position when the jury is considering, the question of guilt. And so to go back to what you were saying, Judge Kuzama, about putting them together, if we're going to apply a cumulative error, this third sub-issue on the appeal is cumulative error. Do we rise to that level? And again, the state would say, no, we're applying a fundamental error standard. It would have to be that these two statements compelled the verdict in this case, that it could not have been obtained without it. And for that to be found, this court would have to find that this jury ignored what they knew to be true collectively. Everybody there taking notes, talking together in deliberation says, we all have a collective amnesia. Maybe the prosecution was right. It didn't say accident. I don't believe that we can find that. I don't believe the evidence supports that. And the other thing is that the substantial competent evidence supported the jury's verdict. As I was saying, we've got the statements that he made. And I think what's important is when the state is sort of talking about, you didn't say this, you didn't say that. Part of this is the crux of the defense is I was asleep and my hand fell. And the prosecutor were pointing out throughout the trial, this is not what you said until we got here to the courthouse. This is not what he said when his wife confronted him. Immediately after the touching, the child jumps off the couch, she goes outside and she reports to her mother immediately, comes back inside and reports to grandma immediately. And at no time does the word sleep or anything like that excuse come up. Then when his wife walks out of the bathroom, before she even has a chance to confront him, he says, I didn't do anything. And at that point, he doesn't say, because I was sleeping and my hand fell. And thereafter, when he's talking on the control call, he doesn't talk about being asleep. When he's talking to his parents in the jail call, which prosecutor did talk about, because in the jail call, he uses personification when he says, I've messed up. I have ruined my life. I love my wife and I can't believe I did this to her. And I've disappointed you as parents. And then his father says, well, you disappointed yourself. And he says, yes, that's true. So all throughout this time, the crux of the defense at trial, I was asleep and my hand fell, was not something that was developed. There wasn't evidence to support it. And so when the jury is evaluating the prosecution's attack on closing argument, saying, this is what you said and didn't say, I think that we can imagine the jury to be smart enough to recognize, A, that was a misstatement, disregard it, but B, that's right. This whole defense is not something that he made in the face of, I think it cannot be disputed. This was a close, loving family. Nobody, his ex-wife, grandmother, the mother of the child whom he raised, nobody says, this guy's a creep and he does terrible things. To the contrary, hard worker, good family man, one-time thing. But it's still a one-time thing. And in the face of all the people who love him, his parents, his wife, his stepdaughter, his granddaughter, all these people who love and support him, never once does he give the excuse of, I was sleeping, and that this touch happened as a result of that. And that was the closest in time to the event. And so that's when you would think, he would say, wait, there's been a misunderstanding, mistake. And that's how the prosecution used mistake, really. Like, she's mistaken, that touch was not that kind of touch. And even when the touch happens, child jumps up, she goes outside. He follows quickly thereafter. He says it was to smoke. The jury rejected that because they found him ultimately guilty. But he goes outside and he testifies the child was crying. And that's another area where everybody agrees there was some kind of touching. The question was, what was the intent? And so when the child jumps up and runs outside, she immediately knows this is bad touch. This is wrong. It doesn't feel like it's always felt, because they were physically, it seems, affectionate. They would snuggle on the couch and she was there every weekend. So when this weird aberrational touch happens, the child, who was 12 going on 13, recognized that this is not normal. immediately tells the mother, immediately tells the grandmother, and everybody gets on board. This is not right. And it's affirmatively wrong. And that is his chance to say what he needs to say to get himself out of this quandary. And instead, he sort of waffles and he tries to deny it. And even when you look at the control call, and of course, when this court again reviews the recording of the control call, you hear this, the police officer is telling the child, say this, say that. And so she says, why did you do this? Why did you do that? And each time we have him creating this sort of pattern of denial. I didn't do it. And then, I didn't, it was an accident. I didn't do it, but I'm sorry I made you feel bad. And it was this kind of opportunity was there to explain his actions.
And all that was the jury.
Yes, Your Honor. That is my.
The jury, I think in terms of determination for us, does this go to the heart of the case? Was he given a fair trial, given those comments, given these two incidents? And for us to determine if it really goes to the heart, would the jury really persuaded or by those two improper? I mean, we could agree, shouldn't have made that statement like Adam and Eve. It's just like as Judge Rose said, no good things come out when we make any reference to biblical. But in this case, it wasn't like some cases that have been cited to where
Yes.
the Ten Commandments says, thou shalt do this, and I'm directing you as jurors, you shall. We're not dealing with that.
No.
I think it's more like perhaps what Judge Yurko said. It was a play on words. I think the prosecutor was trying to be cutesy.
Yeah.
Follow the hand, follow the this, reminds me, follow the man, follow the hand. Because that seemed, the transcript seemed to be lyrical in that
Yes,
sense when you read
yes.
that. But given all that, our determination is, does it rise to the level?
I agree with the court's characterization of what's the issue. And obviously, from my presentation, we believe it does not rise to the level of fundamental error, but not even, there's no reasonable probability based on this evidence that the jury's verdict was a result of these two, this one reference and this one misstatement. And because of that, there is no basis for appellate relief, and we ask that this court affirm the conviction. And if the court has no further questions, I'll conclude my remarks. Thank you very much, Your Honors.
Thank you, Your Honor. I think Judge Kuzian, you correctly identified the question before the court, which is whether Mr. Gilliam was given a fair trial. In evaluating that question, the court must consider the context that this was indeed a very close case. The allegation here was of a brief touching. AM, the child, said the touching was intentional. Mr. Gilliam testified, and he denied. He said that any touching that happened would have taken place as he dozed off on the couch and his hand fell along AM's leg. This is not a case in which there was physical, medical DNA evidence. As my colleague here alluded to, Mr. Gilliam had known AM her whole life. He had known AM's mother for most of AM's mother's life. There had never been any allegation of any type of impropriety. He had a grandfatherly relationship with his child. He testified about his love for her and that he would absolutely not do anything intentionally to harm her. The incident took place while Mr. Gilliam and the child were on the couch in Mr. Gilliam's living room within the line of sight of Mr. Gilliam's wife, who's the child's grandmother. And Mr. Gilliam gave a very reasonable explanation for why he would have dozed off that day. There was actually a fair amount of evidence in this very short trial about why Mr. Gilliam would have been so tired as to have dozed off, in the early evening on his couch. And assuming that the jury believed everything that the child said had happened on that couch, it could very easily have also believed Mr. Gilliam's explanation of it and understood that if any physical contact did take place, it was not intentional, it was not with lascivious intent. So the end result of this was that the jury was left with a very narrow question. This wasn't a question about who did it. And given that Mr. Gilliam was dozing off when this incident happened, he didn't deny that some kind of touching, like what the child described, could have occurred. The whole case turned on what was in his mind as he sat on his couch next to this child who was in essence a granddaughter to him, in full view of his wife. Did he at that time deliberately choose to touch her with lascivious intent? And then the jury that was faced with that question was reminded of the biblical story of the original sin, with Mr. Gilliam cast in the role of Adam, the man who gave into temptation and introduced sin into the world. There was no evidentiary basis for that. And then just before the case went back to the jury, the prosecutor misstated Mr. Gilliam's own words from the night of the incident, and he turned them on their head. It's not just that he misstated them, he turned them upside down. Mr. Gilliam said, "It was an accident, really. I was not trying to do anything wrong." In the prosecutor's telling, that became that Mr. Gilliam did not say that he didn't mean to, did not say that it was an accident, did not say that he didn't know what he was doing. And according to the prosecutor, never once do you hear the word mistake, never once accident. That was false, and it was prejudicial. Mr. Gilliam was denied a fair trial, and we would respectfully request that the court reverse his conviction and grant him a new trial. Thank you, Your Honors.
Thank you both.
Take a photo of the bench with the.
Absolutely.
Okay. How about the?
You don't have this much fun in
Okay.
oral arguments.